Thank you. I received a letter from the Veterans Administration Regional Office on August 25, 2015.
Department of Veterans Affairs, Milwaukee VA Regional Office, August 25, 2015.
Dear Mr. Tui, you have filed a notice of disagreement with our action. This is the first step in appealing to the Board of Veterans Appeals, BVA. This letter and enclosures contain very important information concerning your appeal. Statement of the case. We have enclosed a statement of the case, a summary of the law and evidence concerning your claim. This summary will help you to make the best argument to the BVA on why you think our decision should be changed. What you need to do. To complete your appeal, you must file a formal appeal. We have enclosed VA Form 9, Appeal to the Board of Veterans Appeals, which you may use to complete your appeal. We will gladly explain the form if you have questions. Your appeal should address 1. The benefit you want, 2. The facts in the statement of the case with which you disagree, and 3. The errors that you believe we made in applying the law. When you need to do it, you must file your appeal with this office within 60 days from the date of this letter or within the remainder, if any, of the 1-year period from the date of the letter notifying you of the action that you have appealed. If we do not hear from you within this period, we will close your case. If you need more time to file your appeal, you should request more time before the time limit for filing your appeal expires. See Item 5 of the instructions in VA Form 9, Appeal to Board of Veterans Appeals, Hearings. You may have a hearing before we send your case to the BVA. If you tell us that you want a hearing, we will arrange a time and a place for the hearing. VA will provide the hearing room, the hearing official, and a transcript of the hearing for the record. VA cannot pay any other expenses of the hearing. You may also have a hearing before the BVA, as noted on the enclosed VA Form 9, Appeal to the Board of Veterans Appeals. Do not delay filing your appeal if you request a hearing. Your request for a hearing does not extend the time to file your appeal. Representation. If you do not have a representative, it is not too late to choose one. An accredited representative of a recognized service organization may represent you in your claim for VA benefits without charge. An accredited attorney or an accredited agent may also represent you before VA, and may charge you a fee for services performed after the filing of a notice of disagreement. In certain cases, VA will pay your accredited agent or attorney directly from your past due benefits. For more information on the accreditation process and fee agreements, including filing requirements, you and/or your representative should review 38 U.S.C. Section 5904 and 38 CFR Section 14.636 and VA's website at http://www.va.gov/org/accreditation.asp. You can find the necessary power of attorney forms on this website, or if you ask us, we can send you the forms. You can also find the names of accredited attorneys, agents and service organization representatives on this website. What we will do, after we receive your appeal, we will send your case to the BVA in Washington, D.C. for a decision. The BVA will base its decision on an independent review of the entire record, including the transcript of the hearing, if you have a hearing. Sincerely yours, Regional Office Director, VA Regional Office. Enclosures, VA Form 9. CC, the Veterans of Foreign Wars of the U.S. Statement of the Case. Department of Veterans Affairs. Milwaukee VA Regional Office, August 25, 2015. Name of Veteran, Tui, Thomas A. Issue, entitlement to a waiver of overpayment in the amount of $40,238. Evidence. Review of your file. On March 13, 2014, VA received VA Form, Financial Status Report and Statement where you requested a waiver of the overpayment. On April 24, 2015, VA processed your request for a waiver and sent you a denial letter explaining our decision. On June 1, 2015, VA received your notice of disagreement. Adjudicative actions. Military service, You served honorably in the United States Army for the period 06/30/1970 through June 22, 1973. November 12, 2013, due process letter sent. January 23, 2014, the Pension Management Center, PMC, processed an award terminating benefits. February 8, 2014, the Debt Management Center, DMC, informed the veteran of the overpayment. March 13, 2014, the DMC received VA Form 21 5655, Financial Status Report and Waiver Request. May 15, 2014, the PMC processed an award which reduced the overpayment amount. January 23, 2015, the Committee on Waivers and Compromises, CAWC, received waiver request from the DMC. 04/16/2015, CAWC solicited for a new financial status report due to previous FSR being misplaced. April 23, 2015, new FSR received from the veteran. April 24, 2015, the committee denied the request for a waiver of the overpayment and sent a letter explaining our decision. June 1, 2015, notice of disagreement received. July 22, 2015, CAWC received the notice of disagreement from the DMC. Pertinent laws, regulations, rating schedule provisions. Unless otherwise indicated, the symbol section denotes a section from Title 38 of the Code of Federal Regulations, Pensions, Bonuses and Veterans Relief. Title 38 contains the regulations of the Department of Veterans Affairs which govern entitlement to all veteran benefits. Section 3.102, New, Reasonable Doubt. It is the defined and consistently applied policy of the Department of Veterans Affairs to administer the law under a broad interpretation, consistent, however, with the facts shown in every case. When, after careful consideration of all procurable and assembled data, a reasonable doubt arises regarding service origin, the degree of disability, or any other point, such doubt will be resolved in favor of the claimant. By reasonable doubt is meant one which exists because of an approximate balance of positive and negative evidence which does not satisfactorily prove or disprove the claim. It is a substantial doubt and one within the range of probability as distinguished from pure speculation or remote possibility. It is not a means of reconciling actual conflict or a contradiction in the evidence. Mere suspicion or doubt as to the truth of any statement submitted, as distinguished from impeachment or contradiction by evidence or known facts, is not justifiable basis for denying the application of the reasonable doubt doctrine if the entire complete record otherwise warrants invoking this doctrine. The reasonable doubt doctrine is also applicable even in the absence of official records, particularly if the basic incident allegedly arose under combat, or similarly strenuous conditions, and is consistent with the probable results of such known hardships. Authority, 38 U.S.C. 501A. Section 3.159, New, Department of Veterans Affairs Assistance in Developing Claims. A. Definitions. For purposes of this section, the following definitions apply. 1. Competent medical evidence means evidence provided by a person who is qualified through education, training, or experience to offer medical diagnoses, statements, or opinions. Competent medical evidence may also mean statements conveying sound medical principles found in medical treatises. It would also include statements contained in authoritative writings such as medical and scientific articles and research reports or analyses. 2. Competent lay evidence means any evidence not requiring that the proponent have specialized education, training, or experience. Lay evidence is competent if it is provided by a person who has knowledge of facts or circumstances and conveys matters that can be observed and described by a layperson. 3. Substantially complete application means an application containing the claimant's name, his or her relationship to the veteran, if applicable, sufficient service information for VA to verify the claimed service, if applicable, the benefit claimed and any medical conditions on which it is based, the claimant's signature, and in claims for non-service-connected disability or death pension and parents' dependency and indemnity compensation, a statement of income. 4. For purposes of paragraph C4I of this section, event means one or more incidents associated with places, types, and circumstances of service giving rise to disability. 5. Information means non-evidentiary facts, such as the claimant's social security number or address, the name and military unit of a person who served with the veteran, or the name and address of a medical care provider who may have evidence pertinent to the claim. B. VA's duty to notify claimants of necessary information or evidence. 1. When VA receives a complete or substantially complete application for benefits, it will notify the claimant of any information and medical or lay evidence that is necessary to substantiate the claim. VA will inform the claimant which information and evidence, if any, that the claimant is to provide to VA and which information and evidence, if any, that VA will attempt to obtain on behalf of the claimant. VA will also request that the claimant provide any evidence in the claimant's possession that pertains to the claim. If VA does not receive the necessary information and evidence requested from the claimant within 1 year of the date of the notice, VA cannot pay or provide any benefits based on that application. If the claimant has not responded to the request within 30 days, VA may decide the claim prior to the expiration of the 1-year period based on all the information and evidence contained in the file, including information and evidence it has obtained on behalf of the claimant and any VA medical examinations or medical opinions. If VA does so, however, and the claimant subsequently provides the information and evidence within 1 year of the date of the request, VA must re-adjudicate the claim. Authority: 38 U.S.C. 5103. 2. If VA receives an incomplete application for benefits, it will notify the claimant of the information necessary to complete the application and will defer assistance until the claimant submits this information. Authority: 38 U.S.C. 5102b, 5103a3. C. VA's duty to assist claimants in obtaining evidence. Upon receipt of a substantially complete application for benefits, VA will make reasonable efforts to help a claimant obtain evidence necessary to substantiate the claim. In addition, VA will give the assistance described in paragraphs C1, C2, and C3 to an individual attempting to reopen a finally decided claim. VA will not pay any fees charged by a custodian to provide records requested. 1. Obtaining records not in the custody of a federal department or agency. VA will make reasonable efforts to obtain relevant records not in the custody of a federal department or agency, to include records from state or local governments, private medical care providers, current or former employers, and other non-federal governmental sources. Such reasonable efforts will generally consist of an initial request for the records and, if the records are not received, at least one follow-up request. A follow-up request is not required if a response to the initial request indicates that the records sought do not exist or that a follow-up request for the records would be futile. If VA receives information showing that subsequent requests to this or another custodian could result in obtaining the records sought, then reasonable efforts will include an initial request and, if the records are not received, at least one follow-up request to the new source or an additional request to the original source. 1. The claimant must cooperate fully with VA's reasonable efforts to obtain relevant records from non-federal agency or department custodians. The claimant must provide enough information to identify and locate the existing records, including the person, company, agency, or other custodian holding the records, the approximate time frame covered by the records, and, in the case of medical treatment records, the condition for which treatment was provided. 2. If necessary, the claimant must authorize the release of existing records in a form acceptable to the person, company, agency, or other custodian holding the records. Authority: 38 U.S.C. 5103a(b). 2. Obtaining records in the custody of a federal department or agency. VA will make as many requests as are necessary to obtain relevant records from a federal department or agency. These records include but are not limited to military records, including service medical records, medical and other records from VA medical facilities, records from non-VA facilities providing examination or treatment at VA expense, and records from other federal agencies, such as the Social Security Administration. VA will end its efforts to obtain records from a federal department or agency only if VA concludes that the records sought do not exist or that further efforts to obtain those records would be futile. Cases in which VA may conclude that no further efforts are required include those in which the federal department or agency advises VA that the requested records do not exist or the custodian does not have them. 1. The claimant must cooperate fully with VA's reasonable efforts to obtain relevant records from federal agency or department custodians. If requested by VA, the claimant must provide enough information to identify and locate the existing records, including the custodian or agency holding the records, the approximate time frame covered by the records, and, in the case of medical treatment records, the condition for which treatment was provided. In the case of records requested to corroborate a claimed stressful event in service, the claimant must provide information sufficient for the records custodian to conduct a search of the corroborative records. 2. If necessary, the claimant must authorize the release of existing records in a form acceptable to the custodian or agency holding the records. Authority: 38 U.S.C. 5103 AB. 3. Obtaining records in compensation claims. In a claim for disability compensation, VA will make efforts to obtain the claimant's service medical records, if relevant to the claim, other relevant records pertaining to the claimant's active military, naval or air service that are held or maintained by a governmental entity, VA medical records or records of examination or treatment at non-VA facilities authorized by VA, and any other relevant records held by any federal department or agency. The claimant must provide enough information to identify and locate the existing records including the custodian or agency holding the records, the approximate time frame covered by the records, and, in the case of medical treatment records, the condition for which treatment was provided. Authority: 38 U.S.C. 5103 AC. 4. Providing medical examinations or obtaining medical opinions. 1. In a claim for disability compensation, VA will provide a medical examination or obtain a medical opinion based upon a review of the evidence of record if VA determines it is necessary to decide the claim. A medical examination or medical opinion is necessary if the information and evidence of record does not contain sufficient competent medical evidence to decide the claim, but A. Contains competent lay or medical evidence of a current diagnosed disability or persistent or recurrent symptoms of disability. B. Establishes that the veteran suffered an event, injury or disease in service, or has a disease or symptoms of a disease listed in Section 3.309, Section 3.313, Section 3.316, and Section 3.317 manifesting during an applicable presumptive period provided the claimant has the required service or triggering event to qualify for that presumption, and C. Indicates that the claimed disability or symptoms may be associated with the established event, injury, or disease in service or with another service-connected disability. 2. Paragraph 4IC. Could be satisfied by competent evidence showing post-service treatment for a condition, or other possible association with military service. 3. Paragraph C4, applies to a claim to reopen a finally adjudicated claim only if new and material evidence is presented or secured. Authority: 38 U.S.C. 5103 AD. D. Circumstances where VA will refrain from or discontinue providing assistance. VA will refrain from providing assistance in obtaining evidence for a claim if the substantially complete application for benefits indicates that there is no reasonable possibility that any assistance VA would provide to the claimant would substantiate the claim. VA will discontinue providing assistance in obtaining evidence for a claim if the evidence obtained indicates that there is no reasonable possibility that further assistance would substantiate the claim. Circumstances in which VA will refrain from or discontinue providing assistance in obtaining evidence include, but are not limited to: 1. The claimant's ineligibility for the benefit sought because of lack of qualifying service, lack of veteran status, or other lack of legal eligibility. 2. Claims that are inherently incredible or clearly lack merit, and 3. An application requesting a benefit to which the claimant is not entitled as a matter of law. Authority: 38 U.S.C. 5103(a)(2). E. Duty to notify claimant of inability to obtain records. 1. If VA makes reasonable efforts to obtain relevant non-federal records but is unable to obtain them, or after continued efforts to obtain federal records concludes that it is reasonably certain they do not exist or further efforts to obtain them would be futile, VA will provide the claimant with oral or written notice of that fact. VA will make a record of any oral notice conveyed to the claimant. For non-federal records requests, VA may provide the notice at the same time it makes its final attempt to obtain the relevant records. In either case, the notice must contain the following information. 1. The identity of the records VA was unable to obtain. 2. An explanation of the efforts VA made to obtain the records. 3. A description of any further action VA will take regarding the claim, including, but not limited to, notice that VA will decide the claim based on the evidence of record unless the claimant submits the records VA was unable to obtain, and 4. A notice that the claimant is ultimately responsible for providing the evidence. 2. If VA becomes aware of the existence of relevant records before deciding the claim, VA will notify the claimant of the records and request that the claimant provide a release for the records. If the claimant does not provide any necessary release of the relevant records that VA is unable to obtain, VA will request that the claimant obtain the records and provide them to VA. Authority: 38 U.S.C. 5103(a)(b)(2). F. For the purpose of the notice requirements in paragraphs B and E of this section, notice to the claimant means notice to the claimant or his or her fiduciary, if any, as well as to his or her representative, if any. Authority: 38 U.S.C. 5102b, 5103a. Section 1.962 Waiver of overpayments. There shall be no collection of an overpayment, or any interest thereon, which results from participation in a benefit program administered under any law by VA when it is determined by a regional office committee on waivers and compromises that collection would be against equity and good conscience. For the purpose of this regulation, the term overpayment refers only to those benefit payments made to a designated living payee or beneficiary in excess of the amount due or to which such payee or beneficiary is entitled. The death of an indebted payee, either prior to a request for waiver of the indebtedness or during committee consideration of the waiver request, shall not preclude waiver consideration. There shall be no waiver consideration of an indebtedness that results from the receipt of a benefit payment by a non-payee who has no claim or entitlement to such payment. A. Waiver consideration is applicable in an indebtedness resulting from work study and education loan default, as well as indebtedness of a veteran borrower, veteran transferee, or indebted spouse of either, arising out of participation in the loan program administered under 38 U.S.C. Chapter 37. Also subject to waiver consideration is an indebtedness which is the result of VA hospitalization, domiciliary care, or treatment of a veteran, either furnished in error or on the basis of tentative eligibility. B. In any case where there is an indication of fraud or misrepresentation of a material fact on the part of the debtor or any other party having an interest in the claim, action on a request for waiver will be deferred pending appropriate disposition of the matter. However, the existence of a prima facie case of fraud shall, nevertheless, entitle a claimant to an opportunity to make a rebuttal with countervailing evidence. Similarly, The misrepresentation must be more than non-willful or mere inadvertence. The committee may act on a request for waiver concerning such debts, after the Inspector General or the Regional Council has determined that prosecution is not indicated, or the Department of Justice has notified VA that the alleged fraud or misrepresentation does not warrant action by that department, or the Department of Justice or the appropriate United States Attorney, specifically authorized action on the request for waiver. Authority, 38 U.S.C. 501A. Section 1.965 Application of Standard. A. The standard equity and good conscience will be applied when the facts and circumstances in a particular case indicate a need for reasonableness and moderation in the exercise of the government's rights. The decision reached should not be unduly favorable or adverse to either side. The phrase equity and good conscience means arriving at a fair decision between the obligor and the government. In making this determination, consideration will be given to the following elements, which are not intended to be all-inclusive. 1. Fault of debtor. Where actions of the debtor contribute to creation of the debt. 2. Balancing of faults. Weighing fault of debtor against Department of Veterans Affairs fault. 3. Undue hardship. Whether collection would deprive debtor or family of basic necessities. 4. Defeat the purpose. Whether withholding of benefits or recovery would nullify the objective for which benefits were intended. 5. Unjust enrichment. Failure to make restitution would result in unfair gain to the debtor. 6. Changing position to one's detriment. Reliance on Department of Veterans Affairs benefits results in relinquishment of a valuable right or incurrence of a legal obligation. B. In applying this single standard for all areas of indebtedness, the following elements will be considered, any indication of which, if found, will preclude the granting of waiver. 1. Fraud or misrepresentation of a material fact, see Section 1.962b. 2. Bad faith. This term generally describes unfair or deceptive dealing by one who seeks to gain thereby at another's expense. Thus, a debtor's conduct in connection with a debt arising from participation in a VA benefits services program exhibits bad faith if such conduct, although not undertaken with actual fraudulent intent, is undertaken with intent to seek an unfair advantage, with knowledge of the likely consequences, and results in a loss to the government. VA, in determining all claims for benefits that have been reasonably raised by the filings and evidence, has applied the benefit of the doubt and liberally and sympathetically reviewed all submissions in writing from the veteran as well as all evidence of record. Decision. Entitlement to a waiver of overpayment in the amount of $40,238 is denied. However, your current balance is $25,255. Reasons and bases. In accordance with 38 U.S.C. 5302, the finding of fraud, misrepresentation or bad faith on the part of the claimant automatically precludes the granting of waiver. Since no such finding has been made, waiver decision is based on the elements that assist in defining the principles of equity and good conscience. In your notice of disagreement you requested that your repayment amount be lowered. You must contact the Debt Management Center at 1-800-827-0648 or by a request in writing mailed to Department of Veterans Affairs, Debt Management Center, Bishop Henry Whipple Federal Building, P.O. Box 11930, St. Paul, Minnesota 35111. You must contact the DMC because they are the office that has jurisdiction with the repayment of your debt to the VA.
For a third time they denied my waiver. They included a statement of the case and accused me for a third time of fraud. If this were a public case and I had the resources, I would bring